For Ontarians facing domestic assault charges, no contact orders are by far the single greatest source of pain and frustration stemming from the case. These orders restrict contact between victims and the individual charged, and they can last for months or even years, even if both parties want them dropped. In the domestic context, no contact orders are intentionally designed to put a relationship on ice. By hanging the threat of additional criminal charges over the head of the person bound by the order, no contact orders play a crucial role protecting victims of domestic abuse from unwanted contact by their abuser. But these orders are standard, and as such, they constitute a one-size-fits-all approach to governing contact in domestic cases. And not all domestic cases are alike. In many instances, the no-contact order is not only unwanted by the parties, but in my experience, a fresh source of mental, emotional, and financial harm. It comes as little surprise, therefore, that my domestic violence law firm gets at least a dozen calls weekly from men and women wanting to remove the no-contact order. Most of these are wives or women in domestic partnerships who never wanted their husband or same-sex partner charged in the first place. Others are complainants or victims who simply want the domestic no-contact order to be removed for practical reasons. These are householders who have no reason to be afraid of their loved one. They often have children to care for, bills to pay, properties to mend. They may have health issues that need tending. They may run a small business with the man or woman on the other side of the case. Although they may entertain mixed feelings about their partner, one thing they're absolutely clear about is their desire to communicate with them like a grown-up. But by far, the majority of the Ontarians who call my domestic law firm to remove no-contact orders are married men. These are often the main breadwinners in a family torn apart by domestic charges. Many of these men feel disoriented and powerless after being banished from their homes and told that they cannot communicate with their spouse or children. Left to pick up the emotional pieces alone, men like these cite a host of reasons for wanting to remove the no-contact order: to help pay with bills, to assist with childcare, to nurse their ill partner or in-law, or simply to say, "I'm sorry." In my experience, these men, like their romantic partners on the other side of the case, entertain a ton of misconceptions about the law of domestic assault in Ontario. Among the most common of these is whether and how quickly the no-contact order can be varied. So let's look at that question, beginning with the basics. Are no-contact orders normal in Ontario domestic cases? Yes. No-contact orders are standard in Ontario domestic violence cases. Whether the victim supports the charges or not, once an individual has been arrested and charged, the police or court will almost always impose a term of no contact between the parties. This order may even extend to children or other individuals deemed to be witnesses by the police. Where do you find no-contact orders? No-contact orders are contained in one of two documents. If the charged person has been released by the police, then the no-contact term will be contained on a document called an undertaking or a Form 10. If, on the other hand, a judge has released the accused person after a bail hearing, say, the terms governing no contact will be contained on a document called a release order. What happens if you violate a no-contact order? Whether contained on an undertaking or a release order, no-contact terms carry the full force of the law. This means that violating a no-contact order can result in a new arrest and the laying of additional criminal charges. It's important to note that the underlying reason for violating the no-contact order won't matter to the police. For example, the fact that a complainant initiated contact will not prevent the police from laying additional criminal charges. I see this situation all the time. Are there exceptions to the no-contact term? Both undertakings and release orders may contain exceptions to the no-contact order. For example, they may permit contact through a mutually agreed third party for childcare purposes. Perimeter restrictions, or the inability to be within a certain number of meters of another person, often also contain an exception to retrieve personal belongings. In every domestic case, the starting point should be to carefully review the terms of your release with the assistance of a lawyer. Now for the big question: can Ontario domestic no-contact orders be removed? The answer is yes. Any term in an undertaking or release order, including those governing no contact, can be modified or even removed. This process must be started by the individual facing the charges. Furthermore, the exact process for varying or removing a no-contact order will depend on one of two factors. First, the form of the release. Is it an undertaking or is it a release order? And second, what is the position of the Crown Attorney's Office in relation to the request? In the rest of this talk, we're going to examine these processes more carefully, including the role of the victim in the process, how long the process can take, and the specific factors that can impact the likelihood of success. Beginning with the role of the victim in removing no-contact orders. Victims play a complex and, by many Ontarian standards, counterintuitive role in domestic cases. Although their wishes can influence the course of a domestic prosecution, they can't prevent the laying of charges, compel the Crown to drop the charges, or even decide whether a no-contact order is lifted. On the other hand, no-contact orders are never reversed without the full support of the complainant. The reasons for this should be quite obvious. Victims of domestic abuse should not have to endure unwanted contact or communication with their abuser. Therefore, if a complainant is opposed to modifying or removing a no-contact order while a domestic charge is before the courts, that is the end of the discussion. The order will not be changed, and clients are advised to move on from the issue. On the other hand, if the complainant wants to reconcile or otherwise to resume a relationship with their intimate partner who is facing the charge, this satisfies a basic precondition for modifying or removing the order. But this is just the starting point, and the desire for a complainant to resume contact by no means guarantees that the no-contact order will be lifted. Once a complainant has determined that they wish to resume contact, what remains is a very careful process of either negotiating the removal of the no-contact order with the Crown Attorney's Office, or, in rare cases, convincing a judge to do the same. Before moving on to a discussion of the actual process, let's briefly examine the different forms that a complainant's input can take. Once a domestic violence charge reaches court, complainants are often invited to give their input in the case through victim services. Staffed by non-lawyers, victim services will contact the complainant from time to time to provide updates in the case and to discuss issues raised by the accused or the accused person's lawyer. This can include canvassing the complainant's views on removing the no-contact order. In most cases, the input of the victim is summarized on a standard bullet point form and left with the Crown Attorney's Office to review on their own time. As a domestic violence lawyer with over a decade of experience in this area, experience has taught me that there is a better way for complainants to help remove no-contact orders. If you're a complainant and you want to help your partner lift the no-contact order, you should strongly consider hiring a domestic violence lawyer. A domestic violence lawyer is in the best position to listen to your story in detail, understand the scope and content of the police investigation, and take the most appropriate and effective steps to advance your interests. Assuming the charged party is also represented by a good lawyer, this can substantially increase the likelihood of modifying or lifting the no-contact order. Although victim services does play an important role in the criminal justice system, they don't represent victims in the same manner than a lawyer would. Victim services simply mediates between the Crown Attorney's Office and the victim, offering emotional support and information along the way. True representation, designed to intelligently advance a client's interests, does not come from victim services, but from counsel. As a former Crown attorney myself, I know that when a complainant retains their own lawyer, this on its own signals that they won't take the case sitting down. Rather than wait for a phone call from victim services or have their input reduced to bullet points, complainants like these take the bull by the horns. Now for the big topic, how to remove no contact orders. So far we've discussed the source of no contact orders. Remember, undertakings or release orders. We've also talked about the most important variable that controls whether they can be modified. That's the complainant's input. And the reason why complainants should retain their own counsel if they really want to maximize the chances of this occurring. Now let's examine the actual process for removing a domestic no contact order, beginning with some basic questions and answers. How are domestic no contact orders removed? The process for removing a domestic no contact order usually begins by submitting an application to the Crown Attorney's office. This application must be completed by the individual facing the charges or their lawyer. Once the application is submitted, it'll be reviewed by a Crown attorney who will then make a preliminary determination about whether or not they would allow or consent to the variation. During this process, the lawyer representing the accused will make representations concerning why the no contact order should be modified. Another reminder to get a good lawyer. If the Crown determines that contact between the parties can be restored, they'll then seek the input of the complainant, which may be through victim services or, better yet, through their own lawyer. If at this stage the complainant is supportive of lifting or varying the no contact order, the Crown can then authorize the application. If the original form of the release is an undertaking, then any modifications to it will take effect as soon as the Crown signs the paperwork and files it with the court. What happens if the Crown denies a bail variation? If the Crown denies the application to vary or lift the no contact order, then individuals facing domestic charges may wish to consider filing a motion to have their undertaking or release order reviewed by a judge. This is a process that I'm going to talk about in greater detail a little bit later on in this talk, because it requires significant preparation, legal knowledge, and in most cases, financial ability. Can a victim apply to remove a no contact order? Quite simply, no. Although victims play a central role in domestic cases, they are not what we call parties to the legal proceeding. This means that they don't have the authority or the standing to initiate applications to vary the terms of an accused person's release. How quickly can you get a no contact order removed? Quite simply, there's no rule of thumb about how quickly a no contact order can be removed. Generally, however, unless a client brings the special motion we just talked about to force the issue, removing a no contact order won't be possible, at least until the first court appearance. That's because the process requires a court file, which the police don't often generate until around that time. Many people ask, why is it so hard to remove the no contact order? Clients facing domestic charges should recognize that the removal of a no contact order is not a right. It's an exceptional request that actually cuts against the standard legal rule that an accused should not be allowed to speak to witnesses or to victims. Even in domestic cases where the victim wants the charges dropped, the modification or removal of a no contact order is completely discretionary. The mere desire of the complainant to resume contact isn't a sufficient basis to grant the request, nor are pressing practical concerns like childcare or finances. The exceptional nature of removing domestic no contact orders underscores the importance of hiring a skilled criminal lawyer who understands domestic violence law. The timing, the foundation, the framing, and the approach to negotiating this exceptional remedy is best left to the skill and expertise of a lawyer who understands this very unique area of law. How do you increase the chances of successfully lifting the no contact order then? There are multiple factors that can impact not only the timing, but the chances of successfully varying the terms governing no contact in domestic cases. Among the most important of these are the following. 1. The seriousness and quantity of the allegations. 2. The complainant's wishes. 3. Whether the client has a prior record for domestic violence or violence generally. 4. Whether the client is represented by the best criminal lawyer for their case. 5. Whether the complainant has hired his or her own counsel. 6. The particular Crown and Crown Attorney's Office that's reviewing the case. And 7. Whether the client is prepared to simply bypass or leapfrog over the Crown's approval by filing that special motion we talked about. So as our final topic, let's talk about what that is. So what is this special motion for removing no contact orders? Well, it's a subject that I talk about in my initial discussion on how to remove no contact orders in Ontario domestic cases. Quite simply, it's not always necessary to obtain the Crown's approval to remove a no contact order. If the Crown refuses to remove a no contact term in an undertaking, clients can apply for a hearing before a judge to review that particular term. If, on the other hand, the original release was by a judge, clients can also have their terms reviewed in the Ontario Superior Court of Justice. These processes are highly technical and time-intensive. They should only be attempted, as I say, by individuals who are represented by an experienced domestic assault lawyer. And it's also advisable for the complainant to have his or her own lawyer as well. This motion involves an actual court hearing where, in some cases, the accused and even the victim may have to give evidence. The process also requires the preparation of careful written materials, often with supporting documentation. Assuming there are good reasons to seek the removal of a no contact order, filing a court motion is the single most powerful instrument in the client's total control for accelerating the process of removing a no contact order. That's because the motion leapfrogs over the Crown and puts the decision squarely in the hands of the court. With effective representation, these applications are often very successful. Wrapping up, I want you to consider 3 simple rules. As a domestic violence lawyer, I understand how frustrating no contact orders can be. I'm mindful of the ways our criminal justice system can sometimes feel like it's infantilizing grown-ups by telling them what they can and cannot do, even if both sides in a case disagree with the justice system. Having now looked at the nuances of the process of removing a no contact order in this talk, I want to assure the men and women of Ontario that are facing domestic cases that their removal is possible. My law firm has done it dozens, if not hundreds of times. But the process requires more than a mere snap of the fingers or an emotional appeal to the Crown. It takes patience, the right lawyer, and a willingness to do what your domestic violence lawyer advises. Follow these 3 simple rules, and in my experience, your chances of success will substantially increase. As always, feel free to contact my law firm if you or a loved one is facing charges in Ontario. My name is Shaffie, and I look forward to seeing you again in the next video.